I never thought I would end up in court over a truck that was parked in my own driveway. But here I was, sitting across from Margaret Henderson, the self-appointed queen of the Riverside Meadows Homeowners Association in Phoenix, Arizona. The whole nightmare started on a Tuesday morning in March, when I woke up to the sound of crunching metal and a woman screaming obscenities that could wake the entire neighborhood. My name is Brennan, and I had moved into this suburban development about 8 months prior, thinking I had found the perfect place to settle down after my divorce. The house was modest but comfortable, a 3-bedroom ranch style with a 2-car garage and a decent-sized driveway. I worked as a contractor, which meant my Ford F-250 was essential to my livelihood. That truck was my office, my storage unit, and my transportation all rolled into one. It was not some pristine showroom vehicle, but it was clean, well-maintained, and most importantly, it was legally parked in my own driveway every single night. The morning of the incident, I had been up late finishing some paperwork for a commercial renovation project downtown. I finally crashed around 2 in the morning and was deep in sleep when the collision jolted me awake at 7:15. I threw on a pair of jeans and ran outside barefoot, my heart hammering in my chest. What I saw made my blood run cold. My truck, which had been parked perfectly straight in my driveway, now had a massive dent in the passenger side. A silver Lexus SUV was embedded in the side of it, steam rising from its crumpled hood. And there, standing next to the wreckage in her velour tracksuit and designer sunglasses, was Margaret Henderson, already on her phone, gesticulating wildly. I rushed over, my first instinct being to check if she was injured. "Are you okay? Do you need me to call an ambulance?" Margaret whipped around, and even through her sunglasses I could feel her glare. "I am fine, no thanks to you. Look what you made me do. Your ridiculous truck was sticking out into the street." I blinked, trying to process what she had just said. My truck was in my driveway. "It has been in the same spot every night since I moved in. It is a hazard," she shrieked, her voice reaching a pitch that made my ears ring. "I was trying to navigate around it, and it is so enormous that I could not see properly. This is your fault, and you will be paying for my repairs." I looked at the scene more carefully. My driveway was set back from the street by a good 15 feet. The truck was positioned with at least 3 feet of clearance from where the driveway met the sidewalk. There was absolutely no way she could have hit it unless she had driven directly into my property. The tire marks on my lawn told the whole story. Deep gouges in the grass showed exactly where she had veered off the street, crossed the sidewalk, rolled over my lawn, and slammed into my parked vehicle. "Margaret, you drove onto my property," I said, trying to keep my voice calm. "Look at the tire tracks. You came straight off the road." I did no such thing. She was practically vibrating with indignation now. I was distracted by that eyesore of a vehicle, and this is what happens when people ignore HOA regulations. That was the first mention of the HOA, and I felt a sinking sensation in my stomach. I had read through the covenants and restrictions when I bought the house. There were rules about lawn maintenance, house colors, and holiday decorations, but nothing about parking commercial vehicles in your own driveway. My truck did not even have any company logos on it. It was just a regular pickup truck that happened to be on the larger side. By this time, several neighbors had emerged from their houses to gawk at the scene. I recognized Tom and Linda from 3 houses down, and the Petersons from across the street. Everyone was staring, some recording on their phones. I felt exposed and embarrassed, even though I had done nothing wrong. "I am calling the police," I said firmly. "We need to file an accident report." "Good," Margaret snapped. "They can cite you for creating a hazardous situation." The Phoenix Police Department arrived about 20 minutes later. Officer Rodriguez stepped out of his patrol car and surveyed the damage with a practiced eye. He took statements from both of us, measured distances, photographed the tire tracks, and examined both vehicles. Margaret kept insisting that my truck had been blocking her path, that it was too large for a residential neighborhood, that it violated HOA rules. Officer Rodriguez listened patiently, taking notes. When he finally finished his investigation, he handed Margaret a citation. "Madam, you are being cited for careless driving and failure to maintain control of your vehicle. The evidence clearly shows you left the roadway and struck a legally parked vehicle on private property." Margaret's face turned an alarming shade of red. "This is outrageous. That truck should not even be there. Check the HOA regulations." Officer Rodriguez looked at me. "Sir, is your vehicle registered and insured?" "Yes, officer. I have all the documentation inside if you need to see it." "That is not necessary. You have not violated any city ordinances. HOA matters are civil issues, not criminal ones." He turned back to Margaret. "Madam, you will need to exchange insurance information with Mr. Brennan. I suggest you contact your insurance company immediately." After the officer left, Margaret refused to give me her insurance information directly. Instead, she called someone on her phone, and within minutes, a tow truck arrived for her Lexus. She left in a huff, being picked up by another woman I did not recognize. I stood in my driveway, looking at the damage to my truck and feeling a mixture of anger and disbelief. The entire passenger side was caved in, the door would not open, and I could see fluid leaking from somewhere underneath. This was going to be expensive. I called my insurance company and filed a claim. They told me they would pursue Margaret's insurance for damages, but I would need to get estimates for repairs. I also called my buddy Jake, who ran an auto body shop in Temp. He came by that afternoon to look at the damage. Jake let out a low whistle. "Man, she really nailed you. This is going to be at least $8,000 in repairs, maybe more once we get into it and see if there is frame damage. Can I still drive it? I would not recommend it. That fluid leak looks like it is coming from the transmission cooler lines. You drive it, and you might blow the whole transmission. Let me tow it to my shop and get started on the estimate." So my truck was towed away, leaving me without my primary vehicle and without my mobile office. I had to rent a truck for work, which was an unexpected expense I really did not need. But I figured once the insurance companies sorted everything out, I would be reimbursed and everything would go back to normal. I had no idea that this was just the beginning of a months-long ordeal that would test my patience, drain my bank account, and nearly cost me my business. 3 days after the accident, I received a certified letter from the Riverside Meadows Homeowners Association. It was signed by Margaret Henderson in her capacity as HOA president. The letter informed me that I was in violation of Section 7.4 of the Community Covenants, which stated that commercial vehicles over a certain size were not permitted to be parked in driveways or on streets within the community overnight. I was being fined $500 and given 30 days to comply or face additional penalties. I read the letter 3 times, each time getting angrier. I pulled out my copy of the HOA covenants and turned to Section 7.4. The section did exist, but it specifically referred to vehicles with commercial signage, vehicles used for hauling hazardous materials, and vehicles that exceeded certain weight classifications. My truck did not meet any of those criteria. It was a standard pickup truck that thousands of people in Arizona owned. Yes, it was a heavy-duty model, but it was not a commercial truck in the sense that the covenant described. I immediately wrote a response letter, citing the specific language of the covenant and explaining that my vehicle did not violate any of the restrictions. I included photos of my truck showing the absence of commercial signage and a copy of the registration showing it was classified as a personal vehicle. I sent this via certified mail to the HOA office address listed on their letterhead. A week later, I received another letter. This one was even more hostile in tone. Margaret had doubled down, claiming that my truck was clearly a commercial vehicle based on its size and capability, regardless of signage or registration. The fine had been increased to $1,000, and I was now being threatened with a lien on my property if I did not pay within 15 days. Additionally, the letter stated that the HOA board had voted to pursue legal action against me for the damages to Margaret's vehicle, claiming that my negligence in parking an oversized vehicle had directly caused the accident. I could not believe what I was reading. Not only was she refusing to take responsibility for driving into my property, but she was actually trying to flip the entire situation around and sue me. I needed legal help, and I needed it fast. I contacted a real estate attorney named Patricia Wu, whose office was in downtown Phoenix. She had good reviews and specialized in HOA disputes. When I met with her and explained the situation, she shook her head with a knowing look. "I see this more often than you would think," she said. "HOA board members, especially presidents, sometimes abuse their power. They interpret covenants in ways that suit their personal agendas. The fact that she hit your truck and is now using her position to retaliate is particularly egregious." "Can she actually put a lien on my house over this?" I asked. "If you legitimately owed the fines, yes, the HOA would have that power. But based on what you have shown me, you are not in violation of the covenant. Her interpretation is overreaching. As for her threat to sue you for her vehicle damage, that is absurd. She was cited by the police for causing the accident. No court is going to find you liable." "So what do I do?" Patricia leaned back in her chair. "First, do not pay the fine. Paying it could be seen as an admission that you violated the covenant. Second, I will draft a response to the HOA on your behalf, making it clear that you are not in violation and that any attempt to place a lien will be challenged in court. Third, regarding her threat to sue if she actually files, we will fight it aggressively. Document everything. Keep all correspondence, take photos, and get statements from neighbors if any of them are willing to support you." I left her office feeling slightly better, but also worried about the mounting legal costs. Patricia charged a reasonable rate, but attorneys were not cheap, and this was clearly going to be a protracted battle. Over the next few weeks, things escalated in ways I never could have anticipated. Margaret began using her position as HOA president to make my life miserable in other ways. I received a violation notice because my grass was allegedly a quarter-inch too long. Another notice came because I had left my garbage cans visible from the street for more than 12 hours after collection. Then there was a complaint about the color of my window shutters, claiming they were not on the approved color palette, even though they were the original shutters that came with the house when it was built. Each violation came with a fine ranging from $100 to $300. I took photos showing that my lawn was well within acceptable height, that my garbage cans were only out for an hour after collection before I brought them in, and that multiple other houses in the neighborhood had the same shutter color as mine. I responded to each notice with documentation proving the violations were baseless, but the notices kept coming. I started talking to my neighbors to see if anyone else had experienced this kind of harassment. Tom, who lived a few houses down, pulled me aside one evening while I was checking my mail. "I heard about what happened with Margaret," he said quietly, glancing around as if worried someone might overhear. "She has been on a power trip ever since she got elected president 2 years ago. She tried to fine us because we planted desert willows in our front yard instead of the pre-approved landscaping options. We had to threaten to lawyer up before she backed off." "Has anyone ever tried to vote her out?" I asked. Tom shrugged. "Most people do not care enough about HOA politics to get involved. She runs unopposed every year because nobody else wants to deal with the headache. Plus, she has a couple of allies on the board who do whatever she says. Janet Morrison and Barbara Chen always vote with her." "What about the other board members?" "There are 5 total. Margaret, Janet, and Barbara are the core group. Then there is Paul Hendricks, who mostly stays quiet and goes along with whatever Margaret wants. The 5th member is Stephen Martinez, and he actually pushes back sometimes, but he is outvoted constantly." This information was useful. If I could get Stephen on my side, maybe I could at least have someone on the board who would speak up about the absurdity of the situation. I asked Tom for Stephen's contact information, and he gave me his phone number. I called Stephen that evening, introducing myself and explaining what had been happening. Stephen sighed heavily when I finished. "I am not surprised," he said. "Margaret has been targeting people she perceives as problems ever since she became president. Last year, she went after the Johnsons because they installed solar panels without getting architectural approval first, even though the state has laws protecting homeowners' rights to install solar. She dragged them through months of hearings before finally backing down when they threatened to sue. "Why do you stay on the board if you disagree with how she operates?" I asked, trying not to sound accusatory. "Because I keep hoping I can be a voice of reason. If I left, she would just replace me with another one of her friends, and then there would be nobody pushing back at all. I have been documenting everything, all the meetings, all the votes, all the decisions. If it ever comes down to legal action, I want there to be a record of what has really been going on." This was better than I had hoped. "Would you be willing to provide a statement about the board's conduct if this goes to court?" "Absolutely. What she is doing to you is wrong, and it is only a matter of time before she gets the HOA into serious legal trouble." While I was dealing with the HOA nightmare, the insurance situation was developing into its own separate disaster. Margaret's insurance company, after investigating the accident, determined that she was 100% at fault and agreed to pay for my truck repairs. However, Margaret filed a complaint with her insurance company claiming fraud, alleging that I had somehow staged the accident. This triggered a secondary investigation that delayed the payout. In the meantime, I was still paying out of pocket for the rental truck and losing money every day that I could not use my own vehicle properly. Jake kept my truck at his shop, doing what repairs he could while waiting for the insurance payment to clear. The estimate had grown to $9,500 once he discovered additional damage to the suspension and undercarriage. My insurance company had paid for the repairs under my collision coverage, minus my $1,000 deductible, but they were supposed to be reimbursed by Margaret's insurance, which would then reimburse me for my deductible. The whole process was turning into a bureaucratic nightmare. Then, about 6 weeks after the initial accident, I was served with legal papers. Margaret Henderson had actually followed through on her threat and filed a lawsuit against me. I stood in my living room, staring at the summons and complaint in disbelief. She was suing me for $15,000 in damages, claiming that my negligent parking of an oversized commercial vehicle in violation of HOA regulations had caused her to swerve and crash, resulting in damage to her vehicle, medical expenses for injuries she claimed to have sustained, and emotional distress. I immediately called Patricia Wu. She actually filed. I just got served. "Bring everything to my office tomorrow morning," Patricia said. "We need to file a response and start building our defense. I have to tell you, Derek, this is one of the most frivolous lawsuits I have seen in years. But we still have to take it seriously." That night, I barely slept. The stress was getting to me. Between the ongoing HOA harassment, the insurance delays, the mounting legal costs, and now an actual lawsuit, I felt like I was drowning. I had always thought of myself as a pretty easygoing guy who got along with everyone. I ran a legitimate business, paid my taxes, kept my property neat, and minded my own business. I could not understand why this was happening to me. The next morning, I met with Patricia and her paralegal, Jenny. We went through everything chronologically, organizing all the correspondence, photos, police reports, and documentation into a coherent timeline. Patricia was particularly interested in the pattern of HOA violations that had been issued after the initial accident. "This is clear retaliation," she said, making notes. "The timing and frequency of these violations, especially given that you have documentation proving they are baseless, shows a pattern of harassment. This actually strengthens your position significantly." "How so?" I asked. "Because it demonstrates that Margaret is abusing her position as HOA president to target you personally. It goes to her credibility and her motivations. When we get to court, we are not just defending against her claim that you negligently parked your truck. We are going to show the judge that this entire lawsuit is part of a vindictive campaign against you because you dared to challenge her interpretation of the HOA rules." "Can we countersue?" I asked. Patricia considered this. "We could potentially file a counterclaim for abuse of process, harassment, and maybe even seek damages for your attorney fees and costs. Let me draft our response first, and we can discuss strategy." Over the next few weeks, Patricia filed our response to the lawsuit, denying all of Margaret's allegations and laying out the facts of what had actually happened. We included the police report showing Margaret had been cited for careless driving, photos of the tire tracks proving she had driven onto my property, and statements from neighbors who had witnessed the aftermath. We also filed a counterclaim seeking reimbursement for my legal fees, the costs of the rental truck, lost business income, and damages for harassment and emotional distress. Margaret responded through her attorney, a guy named Richard Frost, who had a reputation for taking questionable cases. His response to our counterclaim was aggressive and full of legal jargon, but essentially boiled down to denying everything and doubling down on the claim that my truck was the cause of all Margaret's problems. The discovery phase of the lawsuit began, which meant both sides could request documents and information from each other. Patricia requested copies of all HOA board meeting minutes for the past 2 years, all correspondence related to me, documentation of how the board had interpreted and applied Section 7.4 to other residents, and Margaret's complete medical records related to her claimed injuries from the accident. We also requested her phone records to see if she had been on her phone at the time of the crash, which might explain why she had driven off the road. Margaret's attorney fought almost every request, claiming they were overly broad or not relevant. Patricia had to file motions to compel, which meant more court hearings and more legal fees. Every step of the process seemed designed to drain my resources and wear me down. Meanwhile, the HOA continued its harassment campaign. I received a notice that I was required to attend a hearing before the board to address my alleged violations. The hearing was scheduled for a Thursday evening at the community clubhouse. Patricia advised me to attend and to record the proceedings if allowed. I showed up to the hearing with a folder full of documentation and my phone ready to record. The clubhouse was a modest building with a meeting room that had a long table where the board members sat. Margaret was in the center, flanked by Janet Morrison and Barbara Chen on one side, and Paul Hendricks and Stephen Martinez on the other. There were about a dozen other residents in attendance, most of whom seemed to be there out of curiosity rather than any involvement in the matter. Margaret called the meeting to order and immediately launched into a recitation of my alleged violations. She presented photos of my lawn, my garbage cans, and my shutters, all printed out and displayed on a board like I was some kind of criminal. Her tone was sanctimonious and condescending, as she explained to the room how important it was to maintain community standards, and how my repeated violations were bringing down property values. When she finally finished, she looked at me with an expression of smug satisfaction. "Mr. Brennan, you now have an opportunity to respond to these violations. What do you have to say for yourself?" I stood up, trying to keep my voice level. "First, regarding the lawn height violation, I have photos taken the same day your notice was dated showing that my grass was well within the acceptable height range specified in the covenants. In fact, my lawn was shorter than at least 5 other properties on this street that you can see in the background of my photos." I passed copies of my photos to each board member. Margaret barely glanced at them. "Second, regarding the garbage can violation, I have a timestamp on my security camera footage showing that my cans were placed at the curb at 6 a.m. on collection day and brought back to my garage at 4 p.m. the same day, which is well within the 12-hour window allowed in the covenants. I also have footage showing that multiple other homes had their cans out for longer periods without receiving violations. I distributed printouts from my security footage. Janet Morrison actually looked at these with some interest, but Barbara Chen just pushed them aside. Third, regarding the shutter color, these are the original shutters installed by the builder when this home was constructed 4 years ago. There are at least 8 other homes in this community with the exact same shutters, none of which have been cited for violations. I have driven around and documented them. I handed out photos showing the other houses with identical shutters. Stephen Martinez nodded as he looked through them. "Furthermore," I continued, "I want to address the elephant in the room." These violation notices began immediately after I challenged the HOA's interpretation of the parking covenant, and after Mrs. Henderson crashed into my legally parked vehicle. Prior to that incident, I lived here for 8 months without a single violation. The timing and frequency of these notices constitute harassment and retaliation. Margaret's face flushed. "That is a serious accusation, Mr. Brennan. This board has a responsibility to enforce the covenants fairly and consistently." "Then explain why I am the only one being cited for things that multiple other residents are doing," I challenged. "Show me where you have issued similar violations to anyone else in the community." There was an uncomfortable silence. Paul Hendricks shifted in his seat. Stephen Martinez cleared his throat. "He has a point, Margaret," Stephen said. "I have not seen any other lawn violations in the past year, and I know for a fact that the Hutchinsons 3 streets over rarely bring their garbage cans in before the next morning." Margaret shot Stephen a venomous look. "The Hutchinsons are not the ones being discussed at this hearing." "Maybe they should be, if we are being fair and consistent," Stephen replied. Janet Morrison jumped in to support Margaret. "I think it is clear that Mr. Brennan has shown a pattern of disregard for our community standards. The fact that he is now in litigation with our president only reinforces that he is a problematic resident." I am in litigation because your president crashed into my truck and then tried to blame me for her mistake, I said, my patience wearing thin. And then she abused her position to harass me with baseless violations. If anyone has shown a pattern of problematic behavior, it is not me. The meeting devolved into arguing, with Margaret and her allies on one side and Stephen trying to inject some reason on the other. Paul eventually sided with Stephen, which surprised me. In the end, the board voted 3-2 to uphold the violations and assess the fines. However, Stephen made sure that his dissent and his reasoning were recorded in the meeting minutes. After the hearing, several residents approached me to express their support. A woman named Carol told me she had received similar harassment from Margaret years ago over a dispute about a fence. An older man named George said he thought Margaret was out of control and that someone needed to stand up to her. It was gratifying to know I was not alone, but it did not change the immediate situation. As summer arrived and temperatures in Phoenix soared into the hundreds, the lawsuit moved forward. Depositions were scheduled, which meant I had to take time off work to sit in a conference room and answer questions from Margaret's attorney. Richard Frost was exactly as obnoxious as I had expected, asking leading questions and trying to twist my words. Is it not true, Mr. Brennan, that you use your truck for commercial purposes? I use it for work, yes. I am a contractor. And you park this commercial vehicle in your driveway every night. I park my personal truck, which I use for work, in my driveway. It does not have commercial signage and it is registered as a personal vehicle. But you just admitted you use it for commercial purposes. I use it for work. That does not make it a commercial vehicle under the HOA covenant definition. Let me read you Section 7.4 of the covenant, Frost said, pulling out a copy. Commercial vehicles are prohibited from overnight parking in driveways or on streets. Your truck is a commercial vehicle. That is not what the section says, I replied. It specifically defines commercial vehicles as those with signage, those used for hazardous materials, or those exceeding certain weight classifications. My truck meets none of those criteria. Frost moved on to questions about the accident itself, trying to suggest that my truck had been positioned in a way that protruded into the street or blocked visibility. I calmly explained, as I had multiple times before, that my truck was fully on my property, set back from the street, and that Margaret had driven onto my property to hit it. Is it not possible that the size of your truck created a blind spot or visual obstruction that contributed to Mrs. Henderson's inability to navigate safely? No, because she would have had to be driving on my lawn for my truck to obstruct her view of anything. She was supposed to be on the street, not on my property. The deposition went on for hours. Patricia sat next to me the entire time, occasionally objecting to questions or instructing me not to answer when Frost got particularly out of line. When it was finally over, I felt exhausted. Margaret's deposition was scheduled for the following week, and Patricia asked me to attend so I could help her prepare questions. I sat in the same conference room, this time watching Margaret squirm under Patricia's methodical questioning. Patricia started with the accident itself. Mrs. Henderson, can you describe exactly what happened the morning of March 15th? Margaret recited a rehearsed-sounding account. I was driving down my street, as I do every morning, when I noticed Mr. Brennan's oversized truck in his driveway. It is very large and blocks the view. I was distracted by it because it should not be there, and I lost control of my vehicle momentarily. You lost control of your vehicle? I was startled by the truck. Were you looking at the truck when you should have been watching the road? I was trying to navigate safely around it. But the truck was not in the road, was it? It is so large that it feels like it intrudes into the street space. Feels like. Mrs. Henderson, were you or were you not on the street when you lost control of your vehicle? Margaret hesitated. I may have veered slightly. You veered onto Mr. Brennan's property and crashed into his parked truck, correct? It was an accident caused by his negligent parking. Patricia pulled out the police report. According to Officer Rodriguez's report, you were cited for careless driving and failure to maintain control. The officer found no violation by Mr. Brennan. Do you dispute the officer's findings? The officer did not understand the HOA situation. The officer understood traffic laws and property boundaries, did he not? Margaret's attorney, Richard Frost, objected at this point, claiming the question was argumentative. Patricia moved on. Mrs. Henderson, you are the president of the Riverside Meadows HOA, correct? Yes. And how long have you held that position? 2 years. In those 2 years, how many violations have you issued to residents regarding commercial vehicles parked in driveways? I would have to check the records. Let me help you. Our discovery requests show that Mr. Brennan is the only resident who has been cited for a commercial vehicle violation in the past 3 years. Does that sound accurate? Margaret shifted uncomfortably. Mr. Brennan's truck is significantly larger than typical vehicles. But the covenant does not prohibit large vehicles. It prohibits commercial vehicles as defined in Section 7.4. Can you point to any language in that section that covers Mr. Brennan's truck? The spirit of the covenant is to maintain residential character. I asked about the language, not the spirit. What specific language in Section 7.4 applies to Mr. Brennan's truck? Margaret could not answer satisfactorily. Patricia then moved on to the violations that had been issued after the accident. Mrs. Henderson, is it correct that prior to March 15th, Mr. Brennan had never received any HOA violations? I believe that is correct. And after March 15th, he received 5 violations in a span of 6 weeks. He was not in compliance with the covenants. But he provided documentation showing that he was in compliance, did he not? His documentation was not convincing. So when Mr. Brennan provided photos showing his lawn was the correct height, you did not find that convincing. I saw his lawn myself. It was too long. Did you measure it? I could tell by looking. You could tell by looking, but his photos with a ruler showing it was within the acceptable range were not convincing. The deposition went on like this, with Patricia systematically dismantling every one of Margaret's claims. Margaret became increasingly flustered and defensive. At one point, she actually broke down crying, claiming she was being attacked and that this entire situation had caused her immense stress and trauma. Mrs. Henderson, you filed this lawsuit against Mr. Brennan seeking $15,000 in damages. You initiated this legal action. Is that correct? He caused the accident. That is not what I asked. You filed the lawsuit, yes or no? Yes, Margaret admitted reluctantly. After the depositions, Patricia felt confident about our chances if the case went to trial. However, she also warned me that trials were expensive and unpredictable. Judges are human and can make mistakes. If there is an opportunity to settle this on favorable terms, we should consider it. I am not paying her a dime, I said firmly. She hit my truck, she has been harassing me, and now she is suing me for her own mistake. I would rather spend every dollar I have fighting this than give her the satisfaction of getting away with it. Patricia nodded. I understand. Let's proceed toward trial then. As we prepared for trial, Patricia subpoenaed the HOA's financial records and meeting minutes. What we discovered was shocking. Margaret had been using HOA funds to pay for her personal legal fees in the lawsuit against me. This was completely inappropriate and likely illegal. The HOA's insurance should have covered her defense if she was acting in her capacity as president, but personal lawsuits were not covered, and she was not supposed to use community funds for her personal legal battles. Stephen Martinez, the board member who had been documenting everything, provided us with copies of emails showing that Margaret had authorized payments to her attorney without a proper board vote. When Paul Hendricks questioned the expenditure, Margaret had dismissed his concerns, claiming it was within her authority as president. This was a game changer. Patricia immediately filed a motion to add claims against the HOA itself for misappropriation of funds and for Margaret's abuse of her position. We also sent a letter to all the residents in the community informing them that their HOA fees were being used to fund Margaret's personal vendetta against me. The reaction from the community was swift and furious. Dozens of homeowners showed up at the next HOA board meeting demanding answers. Margaret tried to maintain control, claiming that defending the HOA's covenants was a legitimate use of funds, but residents were not buying it. Several people pointed out that the police had found me not at fault, that my truck did not violate the covenants, and that Margaret was clearly using the HOA as her personal weapon. A motion was made from the floor to hold a special election to recall Margaret as president. According to the HOA bylaws, a recall required a petition signed by 30% of homeowners followed by a vote. Within a week, the petition had more than enough signatures. Margaret tried to fight it, claiming procedural irregularities, but Stephen Martinez, who had become the de facto leader of the opposition, made sure everything was done by the book. The recall election was scheduled for August. In the meantime, the trial date was set for September. Margaret was facing pressure from multiple directions now. Her neighbors were turning against her, her misuse of HOA funds was being scrutinized, and the lawsuit she thought would be a slam dunk was falling apart. In late July, about 4 months after the initial accident, Patricia received a call from Richard Frost. He wanted to discuss settlement. Patricia and I met in her office to go over the offer. "They are willing to drop the lawsuit against you if you agree to drop your counterclaims," Patricia explained. "They are also offering to pay your legal fees up to $10,000. What about my other costs? The rental truck, the lost business, all of it?" "They are not offering anything for that. Essentially, they want to walk away with minimal damage and sweep this whole thing under the rug." I thought about it. $10,000 would not cover all of Patricia's fees, and it would not compensate me for everything I had been through. But it would end the legal battle without the risk and expense of a trial. "What do you recommend?" I asked. Patricia leaned back in her chair. "Honestly, I think we should counter. We have them on the ropes. The misappropriation of funds issue is serious and they know it. If this goes to trial, and we can prove that Margaret used HOA money for her personal lawsuit, she could face serious consequences, not just from the HOA, but potentially criminal charges for embezzlement or fraud. So what do we counter with? Full dismissal of their claims with prejudice, meaning they cannot refile. They pay all of your legal fees, not just $10,000. They reimburse you for the rental truck costs and any other documented expenses related to the accident and the lawsuit. And Margaret personally apologizes in writing and agrees to resign from the HOA board. It was aggressive, but I liked it. Let's do it. Patricia sent the counter offer to Richard Frost. 2 days later, he called back. They rejected most of our terms but agreed to pay $20,000 toward legal fees and to drop the lawsuit. They would not agree to Margaret's resignation or a personal apology. We went back and forth several more times. The recall election happened in August, and Margaret was removed as HOA president by a vote of 73%. Stephen Martinez was elected as the new president, and one of his first acts was to hire a forensic accountant to review the HOA's finances. The accountant's report confirmed that approximately $18,000 in HOA funds had been improperly used for Margaret's personal legal fees. With Margaret no longer in control of the HOA, the dynamics changed. Stephen, acting as the new president, sent us a letter stating that the HOA would not be defending Margaret's lawsuit and would be pursuing reimbursement from her for the misappropriated funds. This effectively left Margaret and her attorney on their own. A week before trial, Richard Frost called Patricia with a new settlement offer. Margaret would dismiss her lawsuit with prejudice and pay $25,000 toward my legal fees and costs. In exchange, I would drop my counterclaims against her personally, though the HOA could still pursue her for the misappropriated funds. I talked it over with Patricia and decided to accept. Yes, I could potentially win more at trial, but there was also the risk that something could go wrong. A guaranteed $25,000 would cover most of my legal expenses and some of my other costs. More importantly, it would finally end this nightmare. The settlement was finalized in early September. Margaret's lawsuit was dismissed, and she paid the settlement amount. However, the story did not end there. The HOA, under Stephen's leadership, filed a lawsuit against Margaret to recover the misappropriated funds. They also filed a complaint with the Arizona Attorney General's office regarding possible criminal violations. The Attorney General's office launched an investigation into Margaret's conduct. In November, about 8 months after she had crashed into my truck, Margaret was charged with fraudulent schemes and artifices, a felony under Arizona law. The charges alleged that she had knowingly misused HOA funds for her personal benefit. I followed the case through local news reports. Margaret pleaded not guilty initially, but as the evidence mounted, she eventually accepted a plea deal. She pleaded guilty to a reduced charge, paid restitution to the HOA, was placed on probation for 3 years, and was ordered to complete community service. She also faced a civil judgment from the HOA's lawsuit against her. As for me, I finally got my truck back from Jake's shop in October, fully repaired and looking better than it had before the accident. Margaret's insurance company had eventually paid out after she dropped her fraud allegations. I was reimbursed for my deductible and some of my rental costs. The settlement money helped cover the rest of my expenses, though I still ended up out of pocket a few $1,000s when everything was tallied. The new HOA board, led by Stephen, issued a formal letter to me apologizing for the harassment and clarifying that my truck was welcome to park in my driveway without any violations. They also revised several HOA policies to prevent future abuse of power by board members. Life slowly returned to normal. My contracting business survived the chaos, though I had lost some clients during the months when I was distracted by legal battles. I worked hard to rebuild my reputation and my client base. The neighborhood, meanwhile, became a much more pleasant place to live. Without Margaret's iron-fisted rule, people felt more comfortable actually enjoying their homes instead of constantly worrying about petty violations. I ran into Tom one day while checking my mail, and he grinned at me. "You know, you are a bit of a legend around here now." The guy who stood up to Margaret Henderson and won. I laughed. I did not feel like I was winning most of the time. I felt like I was drowning in paperwork and legal fees. "Yeah, but you stuck it out. A lot of people would have just given up and paid the fines to make her go away. Instead, you fought back and exposed what she was really doing. The whole community is better off because of it." That made me feel good, though I certainly would not have chosen to go through the experience if I had known what was coming. The whole ordeal had taught me some valuable lessons about standing up for yourself, about not backing down when you know you are right, and about the importance of documentation and evidence. Looking back now, more than a year after that terrible morning when I woke up to the sound of crunching metal, I can see how everything unfolded. Margaret Henderson was a person who had gotten used to wielding power without accountability. When someone finally challenged her, she could not handle it and lashed out in increasingly inappropriate ways. Her downfall was ultimately her own doing. If she had just taken responsibility for the accident from the beginning, admitted she made a mistake, and let the insurance companies handle it like normal people do, none of the rest would have happened. Instead, her pride and her need to control everything led her down a path of harassment, abuse of power, and ultimately criminal charges. She lost her position in the community, her reputation, her money, and ended up with a criminal record. All because she could not admit she had made a simple mistake and crashed into a parked truck. As for the truck itself, it became something of a neighborhood mascot. Kids in the area knew it as the truck that took down the HOA president. I got jokes about it being indestructible or having some kind of magical protective powers. I played along with the humor, happy to have the whole situation behind me. The experience also brought me closer to my neighbors. People I had barely known before became friends. We looked out for each other, shared information about our rights as homeowners, and worked together to make sure the HOA remained accountable to the residents rather than the other way around. Stephen did an excellent job as president, running the HOA in a transparent, fair manner that was the complete opposite of Margaret's style. I even started attending HOA meetings regularly, something I never would have done before. I figured if I was going to live in an HOA community, I should at least participate in its governance. I was not interested in being on the board myself, but I wanted to stay informed and make sure that what happened to me never happened to anyone else. The legal battles, the stress, the financial costs, and the months of my life consumed by this situation were not things I would wish on anyone. But I survived it, and I came out stronger on the other side. I learned that you cannot let bullies, whether they are HOA presidents or anyone else, push you around. You have to stand up for yourself, gather evidence, get good legal advice, and fight back when necessary. My truck sits in my driveway every night now, just like it always did, fully legal and fully welcome. No more violation notices, no more harassment, no more frivolous lawsuits. Just a regular guy with a regular truck living in a regular neighborhood in Phoenix, Arizona. And honestly, that is exactly what I wanted from the beginning. The whole experience became a cautionary tale in our community and even spread to other HOAs in the Phoenix area. I was contacted by a few people from other neighborhoods who were dealing with their own HOA problems, asking for advice based on my experience. I always told them the same things. Document everything, know your rights, do not be afraid to get legal help, and do not back down if you know you are right. Margaret Henderson moved out of Riverside Meadows about a year after everything concluded. I heard through the neighborhood grapevine that she sold her house and relocated somewhere in Scottsdale. I never saw her again after the settlement was finalized, and I was perfectly fine with that. I bore her no personal ill will at that point. She had faced consequences for her actions, and that was enough for me. The community thrived under new leadership. Property values actually increased as word spread that Riverside Meadows had reformed its HOA practices. People wanted to live in a neighborhood where they would be treated fairly and where the HOA existed to serve the residents rather than to control them. It turned out that reasonable governance was actually good for everyone. I continued my contracting work, and business picked up significantly. Some of that was probably sympathy from people who had heard my story, but I like to think it was also because I did good work. My truck remained my trusted companion on job sites all over the Phoenix metropolitan area, hauling tools and materials, serving as my mobile office, and never causing any problems for anyone. On the anniversary of the accident, I found myself standing in my driveway, looking at the truck and remembering everything that had happened. It seemed surreal that a simple traffic accident had spiraled into months of legal warfare, criminal charges, and complete upheaval in my community. But it had all really happened, and I had the legal bills and the memories to prove it. Tom walked by and called out to me. "Thinking deep thoughts over there, just remembering," I replied. "It has been a year since all this started." Tom came over and looked at the truck. "That thing has been through a lot, you both have." "Yeah, but we made it through." "You did more than make it through. You made a real difference. The whole neighborhood is better because you refused to be pushed around." We stood there for a moment in comfortable silence. Then Tom headed home and I went inside. My house felt peaceful and safe, the way a home should feel. The constant anxiety about what violation notice might show up next was gone. The dread of checking my mailbox had disappeared. I could just live my life without worrying about an HOA board member with a grudge trying to make me miserable. That night, I went through all the documents from the case one last time. The police report, the photos, the correspondence, the legal filings, the settlement agreement, everything. I organized it all into a folder and put it in a filing cabinet, finally closing that chapter of my life. It was all evidence of a bizarre and difficult time, but it was also proof that justice eventually prevails when you stand up for yourself and refuse to back down. The story of the HOA Karen who crashed into my parked truck and then sued me for leaving it on my own property had come to an end. Not with some dramatic courtroom victory like in a movie, but with settlement agreements, plea deals, and the slow grinding of the justice system. Margaret Henderson faced real consequences for her actions. I was vindicated and compensated for what I had endured. The community was reformed and improved. It was not a perfect ending, but it was a real one, and real was good enough for me. As I turned off the lights and headed to bed that night, I glanced out the window at my truck sitting in the driveway. It was right where it belonged, on my property, legally parked, bothering no one. And that, ultimately, was all I had ever wanted. Just to live my life in peace, park my truck in my own driveway and be left alone. After everything that had happened, I finally had that. The nightmare was over and normal life could resume. Sometimes that is the best victory of all.